On the 15th of May 2021, the High Court of Zimbabwe, Peugeot J, Shore J, Charewa J, issued a landmark judgment in which it held that the tenure of Chief Justice Luke Malaba had come to an end. Retired former Chief Justice Luke Malaba served the country for a period in excess of 40 years, and his service must be recognized differently. In the aftermath of the judgment, both the Minister of Justice, Legal and Parliamentary Affairs was cited as the first respondent, and the Judicial Service Commission, which sought joinder in the matter as the 19th respondent, indicated that they would appeal the judgment. The position is that the High Court issued a declarator or a declaratory order, as was sought by our consultant, Dr. Musa Kika. Whilst an appeal can, all things being equal, be lodged against a declarator, the position in law is that an appeal does not suspend the operation of a declarator. Various authorities resolve this point, and there is all this the law itself. In Econet Private Limited versus Telecel Zimbabwe Private Limited, 1998, Volume 1, Zimbabwe Law Reports, page 149, the correct legal position was articulated as follows. My ruling is in effect declaratory, that is to declare what the law provides. The applicant now enjoys nothing that he did not enjoy before launching the proceedings, except the comfort of having had the court confirm his legal opinions. Still, as the facts reveal a competition for rights in respect of the claims, justice, common sense, and good order require judicial confirmation on the issue, and the seeking of a declaratory order was indicated. Later, the court says, accordingly, in my view, since paragraph 1 of the order granted by Sandura JP was merely confirming the rights of Econet, the noting of the appeal could not suspend the effect of that paragraph, as it does not confer any rights. I take that again. The noting of the appeal could not suspend the effect of that paragraph, as it does not confer any rights. That being the case, the notice of any appeal cannot suspend the operation of the judgment of the High Court of the 15th of May 2021. Honorable Luke Malaba is now the former Chief Justice of Zimbabwe. As a result, in accordance with provisions of Section 181 of the Constitution of Zimbabwe, 2013, the substantive Deputy Chief Justice has now become the country's acting Chief Justice. This is a constitutional imperative. Retired Chief Justice Malaba cannot, for that reason, exercise any function either as the chairperson of the Judicial Service Commission or as a judicial officer, save in rendering judgments in those cases that he had while still a judge. For that reason, if the retired Chief Justice contests the judgment of the High Court, he can only do so in his personal capacity. That position comes with certain consequences for the Judicial Service Commission, and in particular, as regards its right to not an appeal on behalf of the retired Chief Justice. Owing to the gravity of the matter, we wish to advise that we affirm instructions from our consultant, Dr. Musa Kika, to take the necessary legal action, including the institution of proceedings for contempt of court, should the law not be faithfully and scrupulously adhered to. I turn to the statement issued by the Minister of Justice, himself a litigant in the proceedings, which has caused both ourselves as officers of the court and our consultant as the successful litigant grave concern. Our consultant is accordingly taken a very serious view of the matter. We however wish to respectfully decline the inevitable invitation to engage the contents of that matter. As we politely decline that invitation, we make the observation that the minister's statement is actually meant to threaten other judges who may become seized with the offshoots of this dispute. We call upon the Minister of Justice, Legal and Parliamentary Affairs to remain faithful to his obligations as a Minister of the Government of Zimbabwe, a registered legal practitioner, and a litigant. We, however, have instructions to ensure that the seriousness with which the comments are viewed by our consultant and indeed by all right-thinking Zimbabweans be reflected in the corrective action to be taken. For that reason, we advise that a letter has been written to the Registrar of the High Court, the Judge President, and the Honorable Justices who dealt with the matter, requesting the issuance of a citation for contempt of court against the Minister. The legal issues that arise from this matter must therefore be dealt with in the High Court. We believe the Minister must show cause, or be required to show cause, why the High Court must not hold him to be in contempt of court. We are aware that there are so many issues on which the nation justifiably want to hear our voice. We would rather certain voices were heard instead. On our part, we will confine ourselves to the matters of law that we have identified and to the pursuit of the corrective measures demanded by the situation. Lastly, we wish to thank Zimbabweans for believing in an orderly and peaceful resolution of mortal disputation. We thank all those who have avidly defended the Constitution of Zimbabwe and have been anxious to ensure the observance of its text and spirit. We thank you.
Okay. Thank you very much, Advocate. We will take questions. Our panel is available to respond to questions, and let's just indicate if you have a question, raise your hand, identify yourself, then you ask the question.
Thank you very much. My name is Blessed Mutlamhat, Soul TV and radio. My question is...
Hi, Blessed.
How are you doing, Advocate Falco?
I'm sure you're not here to grill me like you did to that other gentleman. Thank you for being here, Blessed.
I wanted to find out, with your guidance, what form of appeal is available, given that the Supreme Court and the Court and the Judicial Service Commission are interested parties, all of them.
I can't give you advice on that. Our consultant was the successful party in the litigation. Our consultant does not intend to appeal. And in fact, our consultant believes that an appeal would be incompetent under the circumstances. I won't get into those details.
My name is Richard Mawiri. Just as clarity again, Advocate. I understand that your consultant will not appeal, but in the event that there is an appeal from the state, who is likely to hear this appeal?
Once again, we are not responsible for deciding. Our courts are constituted. Should anyone want to appeal, should that issue arise, the Constitution of Zimbabwe is clear, and what can and cannot be done is clear not only to lawyers, I believe, but also to lay people in view of the circumstances of this matter. But we do not wish to litigate any matters outside court. We point out, though, that at all times that are going to be material, we insist on the observance of the Constitution. We've thought these things through. We know what may or may not happen. And we are prepared to fight not only in defense of our consultant who has instructed us in this matter, but in defense of the Constitution of Zimbabwe, in defense of the founding values on which that Constitution is based, in defense of constitutionalism, in defense of the rule of law, in defense of the principles that underpin our democracy, and quickly in defense of judicial independence. We're prepared to fight for that.
Before I go to Bless, anybody else with a question? You can go ahead, Bless.
You speak about judicial independence, but the ministry that superintends over the judiciary or over the justice in this country has said that the judiciary is captured. Which independence are you talking about?
Thank you. Those are the contents of the statement that we've read. And I must say, when I read that statement, I queried its authenticity. But the course that we've taken is that the issues raised in that statement are serious. And that is one of the issues that are raised. We've taken a particular view of the matter, and in particular, that those statements scandalize the court. We therefore want to be heard by a court of law in argument over those issues, because that is what the minister has apparently said. And it is for that reason that we've requested the issuance of a citation for contempt of court. The letter that I hold here has been received by the registrar of the High Court. It is made to the attention of the Judge President. It is copied to the honorable judges who heard the matter. You will recall, for some of you who are as old as blessed, that we've been down this road before. In Chinamasa, there's a judgment of the Supreme Court which is called Inre Chinamasa, which deals with these issues. We are of the view that the circumstances of the matter dictate that the procedure set out in Chinamasa be activated. And because we have an interest which arises at two levels: number one, our consultant was the successful litigant in that litigation. Number two, we are officers of the court. We have an interest in having the veracity of those issues dealt with, the effects of the allegations raised by the minister dealt with. We have an interest in ensuring that the minister is required to establish the credibility of the assertions that he has made, because we realize that it has an impact on judicial independence. We realize that it has an impact on the integrity of the courts. We realize that it has an impact on how the nation views the custodians, not just of the law, but of the Constitution of Zimbabwe. Not just of the Constitution of Zimbabwe, but of the legitimate aspirations of the generality of the citizen of Zimbabwe as embodied in that Constitution.
Yeah, if I may just add one point. So our remit and brief in these matters is simple. We are here to protect the Constitution. We are here to vindicate the Constitution. We are not pursuing any political agenda. We reject that insinuation. All we are here as lawyers and advocates is to vindicate the Constitution, to protect a Constitution that was approved by 93% of Zimbabweans, over 3.5 million Zimbabweans, in a referendum that was held on the 15th of March 2013. That constitution is dear to us. That constitution is dear to all Zimbabweans. And I'm sure if you were to talk to the ordinary average person, to Tito, Chendambuyangai, or Cholocho, he will tell you, she will tell you, we are prepared to die for that constitution. So our remit is about the constitution. Our remit is about constitutionalism, and our remit is against the serious threats made against that constitution, particularly threats coming from Constitutional Amendment number 1 and Constitutional Amendment number 2. So that's our role, that's our remit, that's our brief, that's our mandate. Nothing more, nothing less.
Another question? Right. So in the absence of any other questions, thank you very much, ladies and gentlemen, for attending this press conference. And thank you for amplifying our voice in the fight for human rights and the strength of the Constitution. Thank you.